Thank you very much for the presentation and for the opportunity to be here. I want to thank especially the Rachel Carson Center directors and all the staff for making real this possibility. As you can see, today we are going to talk about right of nature recognition in Latin America, nature as a subset of right, nature as a legal entity. This is a process that has started in the first decade of the 21st century. Of the 21st century in two particular countries, Bolivia here, you can see there, and Ecuador there. Two small countries in South America. In the next year, this recognition started to cross the frontiers of these countries to other regional countries there. As you can see, here there are some photos about Argentina, Uruguay, Brazil, Paraguay, Peru, where you can see that the argument of Pachamama, this is an important word today. Pachamama is the Quechua word for Mother Earth. So it's very important, this word, because in Ecuador and in Bolivia we are talking about Pachamama's right recognition, not exactly nature. And since the 2009, this idea started to reach the international file, as for example the United Nations resolutions and reports and different international declarations and projects. As you can see there, in 2009 the United Nations decided to declare the 22 April as the International Day of Mother Earth, and then we have here some other international documents. We will come back before to that idea. And this process for the juridical file is very innovative in different sense. And why this process is innovative? There are some different reasons for that. The first one is that the concept, subject of rights, is an ideal imputation, center of right and legal obligations. Normally in the juridical file, only physics and legal persons are considered as subject of rights. Nature is normally in the legal file considered as an object of exploitation, or recently as an object of protection, and this is a result of different anthropocentric perspectives translations into the legal file. But inside the juridical and the ethical file, in particular since the 70s, there is a series of important discussions about the possibility to recognize nature or animals as subject of rights. Here you can observe some examples of these discussions and different contributions about that. It's a very important writing contribution in the legal file, should have studies from Christopher Stone. Between these discussions, there are different arguments in favor of the right of nature recognitions or the animal right in the specific file of animal ethics. But today we found some juridical systems where the recognition is a reality. These two cases, Ecuador and Bolivia. In Ecuador and in Bolivia, Mother Earth, Pachamama, the Quechua word for Mother Earth, has rights. So now, it's necessary for the juridical file to analyze what is the effective meaning of this recognition, what are the first applications of these new legal tools and their meaning construction process. Is there something new for the environmental protection? Are there some new arguments for the environmental movement? How this argument started to be used? Which new institutions have to be constructed to make real this protection? There are some questions that we can think about. And another reason that I think that is important to make or to think in this process as innovative is that the right of nature recognition is in relation with the construction of an alternative way of life. As you can see here, summa causa or summa camania here are both indigenous people words. In the first case, this one is a Quechua word that means a good way of living, and in this case, summa camania is an Aymara word. In both cases are indigenous people's language in those regions, the Quechua language and the Aymara language in the case of Bolivia, that is this one. And this is an important mark of this process because it allows to show the important place that indigenous people had in these processes in articulation with other important movements, and the environmental one, the feminist, the socialism too. We are going back to these ideas after to explain a little bit more about the summa causa and the summa camania. But one question that is important to the environmental file here is which is the place of Mother Earth's right recognition in this proposal, and which kind of tensions are starting to be visible here. And the next, or the final reason that I think it's important to think at this process as innovative is that these ideas are crossing the Bolivia-Ecuador frontiers and have started to reach in the international environmental discussions. Here, for example, the proposal for Mother Earth's right recognition was introduced into different versions of the zero draft document in Rio 20 process, supported by Bolivia, Ecuador, Costa Rica, and Paraguay. Finally, they don't arrive to obtain a universal declaration for rights for Mother Earth, but here we have an important mark in the final document of Rio 20, The Future We Want. In the paragraph 39, we see that Mother Earth is a common expression in a number of countries, and we can see this situation here, in the context of the promotion of sustainable development. This is an important idea. We are going back to that because Summa Causa and Summa Camania are alternative projects, and they are in discussion with the idea of sustainable development. So something that is important here is to see what is the transformation of the idea in this circulation process into the international file. And another thing that is important is that normally the environmental legal tools and other kind of legal tools are imported in the southern countries from the north. And in this case, we have an inverse process. There is an exportation process of this idea from southern countries to the international legal system. And that's very, very innovative, really. So in this context, the presentation has two parts. The first part, I would like to present you the principal characteristic of this recognition in the two mentioned countries, in Ecuador and in Bolivia, which is the content of Pachamama's right recognition. And in the second one, I would like to present some reflections or research questions where I'm trying to focus my research. But previously, I used to take 1 minute for a very, very short explanation about the different ways to study, to research, or in other words, to look at the juridical file. Normally, in the legal formation, the juridical world, it's analyzed as a group of legal rules without context, without history, without relation with another disciplines. The focus on abstracted standards and regulations generate an enormous loss into the juridical file discussion. Of course, there are some exceptions, as for example philosophy or sociology of law, but they are marginal studies in comparison with the law studies heart. That is a problem. This is a problem for different actors that work with law professors, legislators, but we also can affirm that it's an invisible problem, because there are not so much discussions about that or reflection about that, except in the critical legal studies. And it's really that this is a generalization. There are heterogeneous circumstances, but in general terms, this is the situation into the juridical files research. From this perspective, only the first part of my presentation would have sense to tell you, well, the Constitution of Ecuador said the right of natural recognition is that. But it would be only necessary to present that. But that's really necessary, yes, but as a first step. The second step is to build some research questions that can put in relation law and other files of knowledge, can study the uses of the new legal tools, the creation of new institutions, among other topics, and that is the context of the second part of my presentation. So, the first step, nature rights recognition in Latin America. There you can see some photos from Bolivia and from Ecuador. This was in Bolivia, this was in Ecuador, the constitutional reform, and this is a photo of the referendum, because there was a referendum to say yes or no to the new constitutional text. Ecuador and Bolivia have modified their constitution in the first decade of the 21st century after a long neoliberal period in our continent. There were very important reform processes supported by different actors, and between these actors, the indigenous people had an important role there. In Ecuador, the constitution was approved in 2008 and in Bolivia in 2009. In both countries there was a referendum in which the population voted in favor or not to the new constitutional text. In the case of Ecuador, the 64% say yes to the new constitution, and in Bolivia nearly 62% vote in favor of the new constitutional text. The two texts were presented as a new constitutional pact or refundation, as we can see here in the preamble of both constitutions. As you can see there, in the case of Ecuador, a new form of public coexistence in harmony with nature to achieve the good way of living, the summa causa. This is the alternative proposal. This is the new Ecuador, the new pact in Ecuador, and in the same sense, we found Bolivia anew, with the strength of our Pachamama, Mother Earth, a new history. So this is the sense of these constitutions. We have to think in a new country, a new Bolivia, a new Ecuador. And in relation with the right of nature recognition, there is a difference between the two processes. Because in the case of Ecuador, is the constitution the text where the right of nature recognition exists. There is a chapter, the chapter 7 in the constitution. In the case of Bolivia, we have the Pachamama in the preamble, but then we have two specific law about this subject, about the right of Mother Earth, and another law that is very important because there is an important relation here between the right of Mother Earth and the holistic development for living well, the Summa Camania in Aymara, that alternative proposal. Well, in this context, what is the Ecuador Constitution said about nature? Here you have the text of some articles of the 7th chapter of this Constitution that is titled Right of Nature. The most important articles in this chapter are the first and the second one, the Articles 71 and 72, where nature is recognized as a legal entity. And this is the unique constitutional recognition in the world. Here you have that the right recognized here is the right to integral respect and the right to be restored. This is important because these are new arguments that are starting to be mobilized in this country for different social factors. And in the case of Bolivia, we have here the legal rule of 2010, where there is a description or definition about Mother Earth. And here we can find some words that are very important. There are some words like indivisible, interrelated, interdependent, complementarity, that allow shows a continuum that includes nature as an integral part of social life. This is the idea of Pachamama, of Mother Earth, where everybody part of the same thing, of Mother Earth. There is a continuum there. And there is another idea that is very particular and is not very usual in the legal field. There is a place for spirituality. This is very unusual in the legal field. There is no place for spirituality normally into the regulations. And in this regulation, the 7th article here has a list of the right of Mother Earth. Right to life, to diversity of life, to water, to clean air, to balance, to restoration, to live free of pollution. So in both juridical systems, Pachamama, Mother Earth, or nature, as a legal entity, involves making a series of tools and new legal arguments available that are starting to be used. And the uses of these tools is the first part of my research, where the objective is to identify if it implies better arguments than the already constructed in environmental law, or in other words, what are the possibilities that this type of regulations open. For reconstruct the meaning given at the moment to this legal and constitutional recognition, it became necessary to work in an empirical research to analyze the cases and the conflict where this argument started to be mobilized. In that sense, the starting point is the analysis of two judicial cases. The first one where these arguments were used. The first one refers to the right of a river to not be diverted for its natural course due to the expansion of a road. The Vilcabamba River is situated in the Vilcabamba Valley here. This is Vilcabamba city. In a particular region, that is here in the south of Ecuador, in the Loja province, in this region, it's a particular region that started to being chosen to spend their retirement because there are particular conditions for longevity. The local inhabitants usually live for more than 100 years, so persons from different countries go there in the last part of their life. In that context, the place started to become famous and new roads are needed. So the local state started to contract a road that generated an important damage for the Vilcabamba River. Here, there are some photos of that. So two persons decide to present a judicial claim based in the river's right. The claim gives rise to the first jurisprudence in which a judge settled a dispute on the basis of the right of nature in March 30 in 2011. The Provincial Court of Loja ruled in favor of nature in applying for first time the Article 71 of the new Constitution of Ecuador. This decision is a combination between some traditional environmental tools as the environmental impact assessment and some new arguments. The respect toward the river is one of the most important arguments in this judicial case. And the other one, case in Ecuador, the second judicial case where this type of legal tool started to be mobilized, is connected with the great oil spill that the oil company British Petroleum caused in the shore of the Gulf of Mexico. Through the use of the principle of universal jurisdictions, a group of people from different origins and nationalities submit a claim in November 26 in 2011 before the Ecuador Justice. The claim was founded in the idea that Pachamama constitutional protection only exists in Ecuador, and as the Mother Earth is not divisible, it is possible to present claims before Ecuador court in that kind of cases. The judicial claim here is not economical. There is a process in the United States about that. In this case, the group of people claim for restoration measures, information, and guarantee of not recurrence. Both cases, the first one, Vilcabamba, and this one, are the first one where the right of nature recognition started to be used and started to be mobilized in the judicial decision file, where, as many other legal tools, the sense and implications are turned invisible. In both cases, there are a group of people that present the claim, but other interesting question here is if it's necessary to build some institutional innovation, especially in the right of nature protection. In that sense, it is possible to identify some emergent innovation here. In the regulation of 2012 in Bolivia, there is the creation of the Bolivian Mother Earth Defender. Then we have a project here for a Tribunal for Defense Nature in Galapagos in 2013. And finally, we have here a World Ethical Tribunal on the right of Mother Earth. This last one is a tribunal that has as purpose of take care of some different environmental problems in different countries, and the people, a big part of the people that is here, this tribunal is presided by Vandana Shiva, is part of the claim in the British petroleum problem in Ecuador too. So the question here is to identify in which way these institutions are starting to be designed, and then in which way are starting to work. And these two first cases, the creation of these new institutions are state decisions, these two ones. This one, we can affirm that it's a social proposition that is generated from civil society. Some of the people that take place here, as I said, take place too in the claim before Ecuador justice for the case of British Petroleum. And here it's important to see which are the institutional innovations that are trying to be constructed in this process. But there is another thing, another aspect that I think that it would be interesting to study. That is the uses of some traditional juridical tools for the construction of projects inspired in Pachamama's protection, as this really new project of Chasuni Itete. This was the case of Chasuni Itete, that this project was a creative and innovative idea for the non-exploitation of an oil reserve in Ecuador Amazon. To not carry out this exploitation, the proposition was to use a classical legal tool from the contractual law, the fund trust. The international community was called to contribute to the fund trust in an equivalent amount of the 50% of the earning which Ecuador was receiving. This was based in the co-responsibility principle in relation with global environmental principles. In August 2013, unfortunately, Ecuador decided to end with the project because the contribution has been very low and were declining. Through this project was failed, it is an interesting experience that allowed checking the usefulness from the already existing legal tools in different areas of the legal file. It is possible to recreate the sense of some classic legal tools for nature protection. What other legal tools could be re-examined under this perspective? It is possible to revise, for example, the different legal tools inside the contractual law or the responsibility law. This is the first. This kind of questions, the three of them, I'm trying to work in the first part of my research, and in the second one, I'm working in the articulation among the right of nature recognition and the summa causa, or summa camania, presented as an alternative way of living that is part of the constitutional and legal regulations too. The recent reforms in Ecuador and Bolivia have established as an objective to reach the summa causa, good living, or summa camania, live well, another way to live. There are complex concepts really, but the general idea is to build new way of life. So there are cultural, socio-economic, political and ecological aspects in articulation here, in this idea of summa causa or summa camania. This is visible in constitutional and legal regulation in both countries. It is not exactly the same process in Ecuador and in Bolivia, but a common point is that both are proposals for an alternative way of living. Another common point is the translation into the legal file. As we have observed before, it is part of the Ecuador constitutional preamble, and this concept integrates different articles of the Ecuador constitutional text. And in the case of Bolivia, in the 8th article, we can see here, the 8 articles introduce numerous concepts in different indigenous languages that are recognized as ethical moral principles for a plural society. Here there are different words in Quechua, in Aymara, and in Guarani. That is another indigenous people of the region. And in Bolivia there is too the regulation of 2012 that has as an object to establish the vision and the foundation of the integral development in harmony with Mother Earth to live well. This is very important. And there is here another thing that is important, the different knowledge that we have arrived. There is the science, but we have here local and ancestral knowledge. So as you can see, this idea, the summa causa or summa camania, is presented as an alternative construction, and the environmental problem is one of the dimensions, and the harmony with nature idea assumes an important place here, and as we see before in the preamble of Ecuador Constitution. Another important point here is the recognition about the different weight of knowledge here, the ancestral knowledge. Knowledge is not only inside the file of science, in this constitutional text. In this context, it could be important to observe in which way the Live Well project and the Mother Earth right recognition started to imply some tensions, or how the different way of knowledge could be in dialogue here in this process. And these tensions are observable, for example, in the proposal where nature and sacred spaces could be affected. And this one is a central problem in these countries, in Latin America in general, because we have a lot of natural resources there, and in many cases are the basis of our economies. So one case that allows to analyze these tensions is this. This is a project of a road construction in Bolivia, in the indigenous territory in the National Park Isidoro Secure in 2011 in Bolivia. This was the project of the road here, and this is the National Park. This was a project to extend the transport infrastructure in Bolivia, but part of this route would be situated inside the National Park, where different indigenous people live. There were positions in favor or not to this construction between them, and the Mother Earth right recognition was one of the arguments. In this context, the Confederation of Indigenous People of Bolivia organized a 600-kilometer march by foot for more than 2 months that was started in Trinidad and was ended in La Paz. Here is the beginning point, and here La Paz. After this episode, the project was rejected in October 2011. Here are some photos about the march by foot. That was a very famous problem in Latin America. Everybody was waiting this moment, the final moment of the march. And after this episode, the project was rejected in October 2011, and a special law for thickness protection was approved, but the discussion and the idea to extend Bolivian transport structure continued. This conflict is more than the conflict of a road, and reveals different arguments and visions, inside which the Mother Earth right recognition is one of them. So, which is the role of this argument in this kind of conflict? In which way these arguments appear between the others? How the recognition started to be present in the public policy design and in the decision-making process? In this case, there was a problem because there was no consultation for the people before. And finally, the third and last part of my research here is the circulation of these ideas from these countries to the international legal file. This is the process. We can say that a beginning point is this resolution of United Nations that declared International Mother Earth Day. It was the state of Bolivia who proposed the incorporation of this topic into the United Nations agenda, and since that year, a series of resolutions, reports and documents are present in the international space. In the United Nations there are some relevant documents, such as the resolutions entitled Harmony with Nature. This first one was called International Mother's Day. Then they started to talk about harmony with nature, not about Mother Earth. The Mother Earth disappeared from this resolution. And there are some reports from the General Secretary of United Nations too. So in this circulation process, the concept harmony with nature seems to be transformed in a tension space. From south, harmony with nature is presented as an alternative project, also in discussion with the sustainable development concept. But as you can see here, in this document, it started to be presented as a concept or a sub-item here, sub-item entitled Harmony with Nature under the item entitled Sustainable Development. So you can see there the transformation of the sense of the idea, because harmony with nature is in discussion with the sustainable development or green economy. It's another way to construct another answers for the ecological questions. And there they are trying to put in other place the concept. And Finally, there are some other documents that are important. There is a Universal Declaration of Mother Earth Rights that was approved by 35,000 persons at the World People Conference on Climate Change and Right of Mother Earth in April 2010 in Bolivia. This conference was convened by Evo Morales, the President of Bolivia, after the United Nations Conference of Climate Change that took place in Copenhagen. This text is very, very similar to the national Bolivian law about right of Mother Earth. There is another text that is important too here, the World Water Forum. There is a declaration there that took place, this forum in Marseille, in France, in 2012. And in this final declaration, there is a claim for the recognition of rights of nature. And finally, there is a proposition for a universal treaty for rights of Mother Earth, the proposition that was discussed in Rio 20, is here, Mother Earth Accord. And the text is very similar, this text. It's not exactly the same, but it's very similar to this one. So, these ideas from Bolivia are starting to be present in some international documents. So, in the last part of my research, the objective is to analyze the circulation of that idea and the different transformations of that idea. The idea of right of Mother Earth, harmony with nature, summa causa, summa cammanian, because there is some transformation of this proposal. So, for ending, this set of documents, judicial cases, conflicts, shows the existence of multiple and heterogeneous visions for analyzing environmental problems and for thinking about solutions. It is difficult to predict the successful for nature protection of this proposal, of these new available legal tools and these new institutions that are starting to be created. Even so, I think that it's possible to generate a series of reflections and contributions to the legal institutional file for the protection of nature from the perspective of other countries that have a special and heterogeneous worldview, that are trying to construct something alternative. And well, the objective of my research from the idea that this type of contribution cannot reach the ethical discussions and the issues that belong to the legal file, channeling new arguments for the defense of nature and identifying agendas and challenges. Thank you.